Please be seated. Good morning and welcome to the Court of Appeals of Maryland for the fourth day of our September sitting. We have two cases on the docket for this morning, and we're going to get started with number 4 of the 2022 term, Crawford versus the County Council of Prince George's County, sitting as the District Counsel. Mr. Nelson.
Good morning to the court. Mason Nelson on behalf of the citizen petitioner appellants. And this is a land use case arising out of Prince George's County. And my practice is to, when I file a cert petition, to set forth the policy arguments, trying to summarize the importance of the case, and then if cert's granted, which it is occasionally, I argue the law. But I urge the court not to lose sight of the important policy issues in this case. It's a really important case. This case is the crest of a tsunami in Prince George's County. The circuit court judgment, which this court is reviewing today, was the first circuit court judgment on this fundamental issue. We appealed that decision to the Court of Special Appeals. A week later, we petitioned for certiorari. And in our cert petition, we laid out the other pending cases, and there are more. Just yesterday, while I was here yesterday in this court, my office did 2 more cases. There's another case on Friday. These cases are everywhere. The case concerns a proposed use, which is described by Amazon as Extract 8. This is their statement of justification, and I urge the court to review that document, because these are Amazon's words, but I'll summarize them. But in all my cases, this is the most cogent description of this use. But basically, Amazon has 2 types of facilities. It has a large fulfillment center, which is roughly 1 million square feet. There are a few of those around. There's a few in Baltimore. Then they have what their phrase is last mile facilities, which are scattered around the region, which are, depending on the case, 175, 200,000 square feet. The case here today concerns such a last mile facility.
Counsel, if I could just interrupt.
Yes,
point of clarification. As I understand it, warehouse is defined in the Prince George's County Code, but it's also my understanding that a warehouse is a permitted use under the EIA zone. Is that correct? That's 1. 2, the previous use of this structure was a food warehouse storage facility. So if you could answer those two for me.
I'll take the second one first. It was a Safeway food distribution center, but it was not an e-commerce center where trucks were coming at night and delivering packages to their customers the next morning. What you just referred to in the record was an argument by the district council, not supported by the evidence of the record, but it was a Safeway warehouse. That's that question. The court asked really a question about the land use table. So we know the land has a certain zoning, and we have a land use table, and the land use table tells us, we all know this, what uses are permitted in that zone. Warehouse is a permitted use in the zone. The question is whether this use is a warehouse. There's a preliminary issue that Judge Hodden, we petitioned for cert on that very precise question. In response, the respondents filed no cross petition, and yet they added a second issue to their brief, standing, and they changed the issue on which this court granted certiorari. They changed it from a legal question to a substantial evidence question. And under the authority of the Litz case and Garner versus Archie Glenn, I urge this court not to consider those issues because there was no conditional cert petition filed on their behalf.
But did we, as I understand it, we did not grant cert on that question.
On
correct?
Which question?
The question that you are alluding to.
Well, my clients filed a single issue cert petition on whether this use is a warehouse. I'm paraphrasing.
Okay, right.
Cert was granted.
Right. So that's the answer to my question.
That's the only issue.
Okay.
Thank you.
But doesn't this court always have the ability to look at the standard of review and analyze and make sure that the questions are presented in a way that allows us to answer the question? And I don't necessarily quarrel with you that standing wasn't raised, but doesn't the court always have the ability to determine, recharacterize the question to make sure we're addressing it in the appropriate standard of review? And it appears that the question whether substantial evidence supported the district council's decision affirming the planning board's decision to approve the Amazon proposed warehouse is simply a reformulation of the very question that you asked in your petition.
All right. The court made several statements there. First, the Court of Special Appeals has the right to look at other grounds upon which the trial court's grant could have been sustained. But the Litz case and the Garner case make clear that the rules are different in this court where cert is granted. Then the second point about rephrasing the question, certainly the court has the ability to rephrase the question and has done so in many instances. But a respondent doesn't have the right to unilaterally rephrase the question in such a way to fundamentally change the nature of the question. And I respectfully suggest, Judge Booth, that this is not a substantial evidence question. It's a legal question.
It's a determination whether your client's use fits within the definition of warehouse under the zoning ordinance, isn't it? Or I'm not your client. Oh, Amazon's. I'm sorry.
I understand. And we view that as a legal question. But let me explain why, if I may, why we cert. It's a legal question with a straightforward answer. The zoning ordinance in play here was adopted in about 1970. In 1992, there was an amendment, and this is all on the record, where they added the definition of warehouse unit and distribution facility. That was in 1992, and we quote the definition of where it's all in the extract, but it appears in our brief at page 5 and pages 5 and 6 of our opening brief, the definitions of warehouse unit and distribution facility. Those are the definitions that are driving this analysis. 1992. Amazon didn't exist in 1992. There was no e-commerce retail market in 1992. And indeed, Councilman DeNova said as much in one of the hearings, extract 53, 54, where the world was different, I'm paraphrasing, back then. Well, we all know that there was a sudden change brought about by Amazon in the retail world. And then in 2019, Amazon tried to enter the Prince George's County market with one of these fulfillment centers. This is the Westphalia project. This is in the record. And to facilitate this, to enable this, one of the councilmen introduced a bill, a zoning text amendment, CB 18-2019, to create a new definition, merchandise logistics center. This is we quote this in opening brief 6, merchandise logistics center. A facility located within a regional urban community where goods or products are received and may be sorted, packed, and stored for the purpose of distribution to parcel carriers or delivery directly to a customer, and which may include ancillary and related functions such as indoor, outdoor loading and unloading, etc. That's we quoted in full in opening brief page 6. So this was 2019. This is in recognition of this new retail market brought about by Amazon.
And that provision was struck down by the circuit court?
It was.
So that's not in effect right now?
No. And this is what we cited that in opening brief. Our point is the district council knew how to define a use that would describe the use at issue here. In fact, I was a lawyer, got it struck down, right? We all know, it's in our papers. It was struck down for failure, lack of public notice. But there was a series of hearings on this. And this is what Karen Zavakis testified. And my colleagues say this is not legislative history. I reject that characterization. This is legislative history. This is the testimony of the zoning and legislative counsel for the county council. And council persons ask me, well, what is this merchandise logistics center? Well, a merchandise logistics center is not intended to be a warehouse. Not intended to be a warehouse. If the definition is crafted as precise as we hope, The idea is it's basically a touchdown place where the product goes in anticipation of being dispatched to a local or very nearby local area. The idea behind it is that nothing lingers. It is not a storage hub or any kind of warehouse type of facility, as our local zoning laws contemplate that. I couldn't have said it better myself. This is a representative of the county testifying. Now, Amazon says, well, they try to minimize that. Who is Karen Zavakis? I'll tell you who she is. She is the zoning and legislative counsel for the county council who's advised the council, and after she testified, the sponsor of the bill did not correct her. This describes the use. It proves, even though it was struck down, that the council knew that an Amazon facility is not a warehouse. Why else then would they create a new definition? So that's the point there. And the next point is, this case is complicated because I opened my remarks by saying this zoning ordinance was enacted in 1970, amended in 1992, and during the course of this case, the long effort to bring a new zoning ordinance on board was going through. It was enacted, we have the precise date in our paper, but wouldn't go into effect for a period of time. So now we have a new zoning ordinance not controlling, and once again, I'm making the point that the new zoning ordinance informs the analysis of whether this proposed use is a warehouse.
Isn't that sort of like subsequent remedial measures?
I'm sorry.
Isn't your argument similar to the concept behind subsequent remedial measures are not admissible?
No.
If you're going to penalize somebody for clarifying something.
No, with all due respect to the court, I categorically disagree. The jurisprudence in this court is that if there's evidence that a legislative body knows how to do something, it informs their judgment when they didn't do it. So here what we have the 2019 description, Merchandise Logistics Center, before our case. We have a new zoning ordinance which describes a distribution warehouse, which I believe is not a remedial measure, is not analogous to a remedial measure, but informs the question of whether what is a warehouse. A warehouse is not something described by a merchandise logistics center. A warehouse is not something described as a distribution warehouse, which they define as a facility primarily engaged in the distribution of manufactured products, supplies, and equipment. It includes the temporary storage of such products, supplies, and equipment pending distribution. That's this use. So these definitions of merchandise logistics center, the definition of distribution warehouse in the new ordinance, make clear that the district council knew how to define a use that would include this description as described on page 8 of the extract, and they didn't do it. And it's evidence that this proposed use does not fall within the definition of a warehouse.
Counsel, does the Prince George's County ordinance define the period of time that the goods can be stored in the facility before they are distributed?
Does not.
And would that have some bearing on your argument?
Well, no argument is black and white. It's a piece of information that deserves consideration, but is not dispositive. So my adversaries argue, there's no time limit. It doesn't matter whether we have it there for 30 minutes or 60 minutes. That's just one piece of the puzzle. One small piece of the puzzle. The bigger pieces are, when these definitions were defined in 1992, these e-commerce world didn't exist. That they tried to define it in 2019 with the Merchandise Logistics Center. They tried to define it in the new zoning ordinance. Those are the big pieces of the puzzle. And that there's no administrative practice interpreted in this way. My adversaries argue deference. I say no, little or no deference. This practice had been in fact for a total of 7 days before this decision was made. 7 days.
Wait, I'm sorry, what had been in effect for 7 days?
The planning board's determination that a use described on page 8 of the extract constituted a warehouse on the zoning ordinance. So The first case was, this evidence is in the file, but first case was what I call the Washington Gateway case. It was 1 week ahead of the schedule in this one. This case came down 7 days later, so that's why 7 days. And the other cases that my colleagues cite are after. So we say there is no long-standing practice. But Judge Hott, may I go back, if it's acceptable, to a question you raised earlier about the is it a permitted use in the zone? And I gave the analogy of the land use table, the zoning map, and so on.
Well, I thought you responded yes.
I
It's
did,
a permitted
but
use.
It is a permitted use, but I just wanted to clarify that this is a comprehensive design. You asked an EIA. A comprehensive design zone permits the EIA zone, which really creates its own use table. And so the use table that we have governing this case is in the extract at page 285 through 298. And so this is the comprehensive design zone. So it's really like its own, it's as if it's its own mini zoning ordinance. And there's a typed version, and I apologize, the font's a little small, but the typed version appears at extract 284. So this is the document that says what are the permitted uses in this zone. And this document at extract 289 says that warehouses and wholesaling establishments are permitted uses. And so when I say a warehouse is a permitted use, that's what I'm thinking about. But this document does other things too. And I'm looking at extract 285. It talks about, it creates a mechanism by which an applicant can seek to add a use to this list of permitted uses in a comprehensive design zone. We briefed this in our papers, and this is extract 285. Applicants for uses not included in the detailed use of list for the center must apply in writing, providing any new information for the planning department to determine whether new use, and it sets forth various criteria. But there's a mechanism in the comprehensive design plan to allow an applicant to add a list to the list of permitted uses, which was not done in this instance. And we think that's further evidence as to why this court should reverse the decision of the circuit court. But let me go back, if I may.
Are you asserting that that is required, or just the statement that they did not?
I'm making both statements.
Okay.
I'm saying, first statement is, there's a mechanism, an administrative mechanism, laid out in extract 285, which describes what they can do to add a use to it. If they thought that their use fit the purposes of the comprehensive zone, here's the mechanism. Submit an application. There can be a public hearing before the planning board. Citizens can oppose it should they choose to. And the planning director or planning board makes a decision.
And your argument is that if it's not a warehouse, they have to follow that procedure. And I don't think they disagree. If it's not a warehouse, the question is it a warehouse?
I take the court's point. Yeah. Yes.
Because you have all these things like a Carty doctrine and other things thrown in, but it all, all of this rises and falls on whether or not it meets the definition of a warehouse.
Yeah. But what I'm really trying to say is if there's any ambiguity, there's a mechanism set forth, an administrative mechanism, which they could have exercised, and would have been done 2 years ago.
As a technical matter, there seems to be a dispute between the parties as to what decision we're actually reviewing here. What's your view of that?
Yeah, Mr. Kumar, I've argued about that. We've talked about that many times. So we know under the Zimmer case, I'm winding down my time, very brief. Under Zimmer, the district council reviews on the record the decision by the planning board. Traditional, and sets forth the standard review for a circuit court review in an agency. Mr. Kumar's point is, It's different here because we're affirming the decision of the planning board. And I say it doesn't matter because they both made the same decision. The decision that the district council made was to affirm the decision of the planning board, except for that factual observation that they threw in about the Safeway facility without any evidence in the record to support it. It's not the same situation. So my reaction is, I don't think it makes any difference. Our arguments hold for the district council as just as much as they do for the planning board.
But didn't the planning board make a recommendation?
No,
It's
no,
the
no.
district council that makes, oh, okay.
No.
Tell me why I'm wrong.
We have to go into the ordinance. There are certain instances where the planning board does make a recommendation. Here, it was not a recommendation. It was a decision that the planning board made, a resolution, not a recommendation. And that under Zimmer, if you do a word search for SDP, which this case is in Zimmer, it'll go straight to the standard review that governs the district council's review of the planning board's decision. And the Zimmer court just summarizes what you and I have read 100 times. When reviewing the decision of the agency, you got to make sure that they get the law correct, articulate their findings, and there has to be substantial evidence to support it. That's the scope of the district council review. Mr. Kumar said, well, what Nelson's arguing about the planning board, they both reach the same result. It makes no difference. So I see my time's up. I'd love to go further, but I'll save my time if that's all right.
Okay, thank you, Mr. Nelson. I think we're going to hear first from Ms. Eisenstein.
Good morning, Your Honor. May it please the Court. Alana Eisenstein on behalf of the appellee, Amazon.com Services, LLC. Mr. Kumar is here from the District Council, and we're splitting time. He's going to primarily handle the issues with respect to the matter that Mr. Nelson just raised about which particular agency decision is reviewed. But we ask that this Court affirm the decision of the District Council because Amazon's approved use of the existing warehouse fell squarely and comfortably into the definition of warehouse and distribution facility that's permitted as of right in the EIA zone where it's located. And it constitutes a warehouse as defined under the Comprehensive Design Zone Plan and the specific Design Zone Plan that was being amended here. What's notable about Mr. Nelson's argument that you just heard is you didn't hear him talk about the actual evidence in the record about what type of use and operations were proposed by Amazon at the facility or the definition of warehouse that applies here under the zoning ordinance. And I think that's telling because the District Council here found that when you look at the record and you apply the definitions in the zoning ordinance to the record, it was, quote, straightforward. And we agree. A warehouse use is a building that is used for storage of goods and materials in connection with the day-to-day operations of a wholesale or distribution business or any other business that's not located at that property. That is exactly what Amazon proposed to do here. Mr. Nelson talks about this somehow being something new or novel, that the e-commerce world changed in some undefined way what's going on at the property, the actual operations of the property, but it does not. The District Council found that this was no different than the use that had been put to this property for over 20 years by the food distribution business that operated there before. And the record establishes that. The record shows that packages at this facility would be delivered, they would be stored, they would be sorted, and they would be distributed. And those that were undeliverable would come back and be stored there again. That is a traditional classic use of a warehouse that is operating in connection with a distribution business or with other businesses and the service operations that they support.
Does it matter to your argument whether it's no different? Does it matter whether it's no different? I mean, one can certainly imagine. I mean, Amazon is different. Right? One can imagine the volume of traffic is significantly different. Does that matter?
So, Your Honor, I think what is, it matters in a way, yes, because I think the definition of warehouse that was employed by the Planning Board and the District Council here for almost 2 decades gives it even additional weight than the substantial deference that would already be accorded to the administrative agency. So contrary to what Mr. Nelson claims, that this is just a 7-day-old policy, I think that the consistency of operations that was found by the District Council weighs in favor not only of the legal interpretation of what a warehouse use under not only the EIA zone, but also under the Comprehensive Design Zone Plan and the specific plan that was approved here. All of that has been consistent for such a long period of time that weighs in favor of deference and affirming the District Council here. In terms of your second question, which is there some implication that because Amazon has a different business model, not the operations, but the e-commerce model, does that lead to additional volume or some kind of other difference in traffic and activity at the site? That was something that was looked at. There was a traffic study that was done here. It was challenged by Mr. Nelson at the circuit court level, but notably not challenged here. And so there was a finding with respect to the level of activity, and the finding by the Planning Board and the District Council and the circuit court were all in line that it was consistent with the type of use that was approved at this property. So I think that the implication, it sort of demonstrates that the implication that Amazon is doing something novel and new here is simply untrue and unsupported by the record. I think it's similarly telling that Mr. Nelson highlights or treats Amazon's different activities throughout the state as a monolith and suggests that a use that was proposed, for example, at a merchandise logistics center that was, first of all, not only struck down and didn't occur, but was a completely different type of facility. And he tries to equate the two. That facility was proposed to be 10 times larger than this one, and the type of fulfillment center that he recognized in the outset of his remarks was very different than the much more modest in scale last mile warehouse that is proposed here. And so the idea that that other zoning ordinance that was later nullified has any bearing here is completely untrue, both by the matter of record evidence and as a matter of law, because the type of proposed facility, the new type of zoning ordinance that was proposed there for that use was for a different use than the use that has been proposed and that's in the record in this case. I think it's also telling that Mr. Nelson no longer presses the idea that this is not a distribution business or not another business that is not co-located at this property. So in his initial papers, he suggested that this didn't constitute a warehouse use because it's not a building used for storage in connection with a distribution business. I didn't hear him say that here today, and that's for good reason, because I think it does meet the definition both of a distribution business or facility, which is defined in the code to include not only wholesale operations, but also a facility to or from which a retailer ships merchandise, materials, or supplies, or the service operation that it supports. And here what you heard in the record was that the packages that are shipped to the location, stored there, they're distributed not to individual consumers who come there, but to a fleet of service vehicles that provide the service that Amazon provides, which is to have a distribution network of vehicles that come and then they go and deliver to the customer. So this is not like a retail store where there's individual people coming, consumers coming to pick up their merchandise. I also wanted to just say something about the outset of Mr. Nelson's argument, where he suggested this is somehow the crest of a tsunami, and in his cert petition made suggestions that there was some kind of rush to get this facility approved under the old zoning ordinance before it was changed in the new zoning ordinance. First of all, there is no record evidence as to that. There is 5 facilities that have been approved in the county that are similar uses, which proposed uses of being a last mile warehouse. Those were each in different zones. This is the only one that was in a comprehensive design zone. The others were in either the IE or IH zones and not challenged here today. And the new zoning ordinance notably carved out the comprehensive design zone as a legacy comprehensive design zone and intentionally grandfathered those provisions in under the old zoning ordinance. So not only is that new zoning ordinance not in effect, not only did it not come into effect until well after the decisions in question here, and so could not have been considered by the planning board or the district council below, but also, even if the new and when the new ordinance applies, it would have no effect on the fact that this proposed use is permitted as of right under the old zoning ordinance. It changes nothing. So I think that the premise of Mr. Nelson's policy type arguments is simply not correct and not a matter of record evidence. I also wanted to say a few words about the standard of review, although Mr. Kumar, I'm sure, will elaborate on that, which is notwithstanding, I think the reason that Mr. Nelson protests the rewording of the question presented is because he wants to avoid the clear deference that is afforded by this court to the district council in reviewing the planning board and affirming the planning board's decision to allow the amendment to the specific design plan as proposed by Amazon. It is the substantial evidence standard. Here, this court has looked at this type of issue of the application of a static table of uses to a proposed set of uses, and so has the Maryland Court of Special Appeals, and they have found repeatedly that that's a mixed question of fact and law that applies a deferential standard and respects the board and district council's expertise in applying its own zoning ordinances to the proposed use. And under that standard, if it's fairly debatable or if reasonable minds could have found the proposed use meets the qualification, then the decision should be affirmed. And that is the case here. The district council and the planning board looked carefully at this question. They had an evidentiary hearing where extensive testimony was provided about the nature of the proposed operations, where both sides presented traffic studies and other information where certain limitations were put on the property to accommodate the area in which it sits. And that carefully determined decision is one that this court would and should apply its deferential standard. There was certainly not only substantial evidence, but again, as the district council found, this was a straightforward question that the proposed use constitutes a permitted use as a warehouse in connection with a distribution facility and other business in connection with it. If there are no further questions, I will yield the rest of my time to Mr. Kumar.
I see no other questions, so thank you, Ms. Eisenstein, and we'll turn now to Mr. Kumar.
May it please the court and the council. Your Honor, this case is about what's called last mile delivery, which is the last leg in supply chain operations. It's not about Amazon. This is a term of art that was created out of the telecommunications industry, and it's literally you're going to the last stop and taking that product to the customer. That operation is permitted in a warehouse. In other words, the packages go to a building. It's not about Amazon. It's about the packages going to a building. Amazon has delivery trucks. They also have a new innovative process where they have cars that go to the delivery station. And this is a delivery station. This is not a merchandise logistical center. So it's very important for this court to refocus from Mr. Nelson's argument that this case is about Amazon's last mile delivery of its product from a warehouse in Prince George's County to a customer. It is not about a public policy. It is not about Amazon taking over Prince George's County. Anyone could have applied for the use and occupancy permit at 1000 Prince George's Way and use that building for the same exact thing, regardless of the name of the company. Mr. Nelson concedes this point in his brief when he says what the court must look at in making the determination, and he says that you look at the operations of the business. You don't look at the name. So Amazon Last Mile should not control the decision here. It's what they're doing in the building should control. With regard to the testimony or Mr. Nelson's brief about the Merchandise Logistical Center, none of that should be a consideration for this court because this was a quasi-judicial proceeding before the planning board. The record started there and it ended there. We do not open the record at the district council. This was an appeal from the citizens to the district council to review the decision of the planning board. And that goes to the standard of review that Judge Baran is talking about. Last Friday, when this court considered the FC Gen case, some of the same kind of debate came about whose decision you look to. The tax court, of course, this court has said you look through the circuit court and look to the tax court. And then the question came up from Chief Judge Fader about, well, do you give deference to the comptroller? We are not saying here that the district council does not give deference to the planning board. Zimmer settled that. When I argued that point, Zimmer rejected it. What happens here is you have to look at the agency's decision. Mr. Nelson appealed to us. Land Use Article 22407 says the statutory authorization to seek judicial review is for the final decision of the district council. Mr. Nelson has never once in his papers argued that the district council erred. So what you have before you here are briefs and papers that has nothing, one paragraph saying that the district council erred in its affirmance of the planning board. What he is arguing is something that we resolved, but he doesn't question how we resolved it. If you remember, when the question was presented below to the district council, because of what Zimmer tells us, we must sit as an appellate court. So when we reviewed that question, whether Amazon Last Mile satisfies the existing definition of a warehouse, we applied what's called rules of statutory construction. We cited in our briefs the Lotchkin case, which came up last week as well. And you look at statutory construction of the entire sections that are relevant here. And on page 12 to 13 of my brief for the council, there are three definitions that are relevant. The definition of a use, the definition of a warehouse unit, and the definition of a distribution center. You just don't look at the definition of a warehouse. A warehouse is a use. You have to look at how we define a use. And a use is very broadly defined in the ordinance. Now, when Mr. Nelson talks about what Ms. Zabako says, it's very important that before the planning board, and Mr. Nelson and I were in court on CB 18 at the time. CB 18 was struck down on Valentine's Day of 2020. The planning board made its decision in July, and the district council affirmed it in October. None of that information is in the record. He did not bring it up before the planning board. He did not bring it up before us. So this court should not consider something what he's trying to argue is a public policy argument because it is irrelevant to the definition of a warehouse. If you take Mr. Nelson's argument, the planning board and the district council would have to stop its work because they passed legislation that is in litigation, but no other definition of the ordinance could ever satisfy a use that has previously existed.
I don't think that's his argument about that. I understand his argument to be more related to the comments that were made that were saying that it wasn't a warehouse.
No, and I understand.
He's not arguing that we should apply that or anything like that. It's really more of the process and what people said and whether that indicates that the use that they're making out of this facility is or is not a warehouse.
And Chief Judge, I understand it the same way. I'm saying something slightly different, that you shouldn't be considering it because this is an evidentiary hearing. None of that was in the evidentiary record. That's the first part. The second part with regard to what he's saying, that we knew what we wanted this to be. One, as my co-counsel said, that this was a different type of facility altogether. And second, in addition to that, the definition at the time that was traveling, if you look at the appendix that I have in my brief, Mr. Nelson argues that it's a special law, it's spot zoning. I can guarantee you the following, because I'm dealing with it right now with Mr. Nelson. Had we passed a law or a regulation or a use that says Amazon last mile is a use, I assure you, as I stand here, I would be in court defending that piece of legislation that it's spot zoning or a special law. The point that I'm trying to make is that nothing satisfies what Mr. Nelson, it's about stopping Amazon. That is the goal. And I find that to be contrary to what this court should be doing. Because
well, this court's here, though, to look at whether, however it's phrased, this is a warehouse.
Correct. So going back to the actual definition of the warehouse, we must look again at what Amazon is doing. Mr. Nelson has offered no evidence, even below, that would suggest that Amazon is not delivering packages there, they're being stored and being delivered to someone else. He claims because Amazon indicated that the packages are there for like 12 hours, that's not storage. But that's not true, because as Judge Houghton indicated, the ordinance does not put some definition standards on storage. And moreover, Amazon's statement of justification indicates that when packages are undeliverable, they go back to this station. At the end of the day, the team sets up this station for the next day delivery. So by definition, things are stored in that building. Storage should not be an issue in this case about whether Amazon is not storing things there. But I want to go to the standard of review, because that's becoming more and more of a problem for us with Mr. Nelson when we go to circuit court. If this court is going to hold that you look through the district council, as Mr. Nelson is asking the court to do, then 22407 becomes meaningless, and really the decision that should go to court is the planning board's. Because if the district council does not have the deference afforded to it because we passed the local zoning laws, we have, and by the way, the words no deference or little deference has been used, but the case law in this court is considerable weight. You give considerable weight to the agency's decision. So our position is that once the case came to the district council and we reviewed it on the statutory construction position, again, Mr. Nelson has never challenged that. Even though cert has been granted, the only question is whether the planning board erred. Then he says in his reply brief, well, we made the same conclusion, so what's the difference? There is a huge difference. Because if you're going to argue that the district council erred, you have to formulate an analysis before the reviewing court so there can be meaningful judicial review of what is it exactly you're claiming is the error. You cannot claim the error is planning board, never make an allegation when you sought appeal to the body to review these errors that we made an error. It's the same thing this court does with the Court of Special Appeals. So we would ask the court to definitively state what the standard of review is when you're reviewing a decision from the district council under 22407, and make clear so we don't go back and forth on these things. And please, I'm not suggesting that the planning board's decision isn't considered as part of the district council's decision. We're reviewing it. There's no question about it. That's the record. But the actual who's getting the deference and who the circuit court should be reviewing should be clarified in this decision, because to me, that is the public policy that is really relevant here. It's not the issue of whether Amazon last mile is a warehouse. It clearly fits the definition of operation and the storage of a warehouse facility that is defined in the ordinance. With regard to the 7-day, the planning board only had 7 days. I view it differently. Planning board has been interpreting that section of the ordinance for decades. In fact, Mr. Nelson placed into the record the 1992 amendment to the ordinance. My argument was not that somehow the 1992 amendment added a use to the CDP. I was arguing that the 1992 amendment amended what the CDP already permitted, which is a warehouse, and it added or distribution business to that definition. So planning board did not just do this in 7 days or only 7 days. Planning board has been interpreting the definition of a warehouse, and Ms. Hewlett, the chair of the commission, said it, and it's in our papers. Ms. Hewlett indicated that we have determined that this is a warehouse, and this is because they have been doing this for decades. It's on page 23 of my papers. And interestingly enough, the legal counsel for planning board, Deborah Borden, indicated that Mr. Nelson injected the evidence into the record that this is a warehouse. In fact, he provided, and this is on page 22 of my papers, block quoting the transcript, the ITE definitions for under land use for traffic, and it was for a warehouse. So the point that
you opened your argument up by saying this is not about Amazon, it's about a last mile facility that you said was conducive to being in a warehouse. Is there anything in the record about that issue that you started out with, of this being a last mile facility having been interpreted as falling within the definition of a warehouse by the planning board or district council?
Well, it's in the record that Amazon, the corporate designation is Amazon last mile.
Right, but you started out your argument by telling us that last mile isn't unique to Amazon. It's something that started in the telecommunication industry, and there are multiple last mile. And then you said, kind of casually, that it can fit within a warehouse, and that's what's being done here. But as you're going through this argument about deference owed, whether it's a long-standing interpretation, I'm bringing you back to that opening to ask, has this been a long-standing interpretation of the board that this sort of last mile facility fits within that definition of a warehouse?
The only case I'm aware of that used the corporate name to the word and added in front of last mile is Amazon. I haven't seen another case that came through, say, like, for example, Walmart last mile or Target.
I thought you opened up by telling us that was a telecommunications.
No, I said that it originated, the word last mile delivery originated from the telecommunications industry because they couldn't get the entire cable all the way to the main network, so they had to do separate cables to individual homes. That's where that term came from. Last mile is just a term. It's not an innovative new use. I see that my time is up. I would ask the court to affirm the district council in its decision affirming the planning board.
Okay, thank you, Mr. Kumar. Mr. Nelson, you have the 10 minutes you have reserved for rebuttal. And I will just point out, the court will be taking a brief 5-minute break between this argument and the next one.
Thank you. Please, the court, Mason Nelson, on behalf of petitioner appellants. First, on the question of the appeal, I direct the court to extract 515. This is our petition for judicial review, where we petition for judicial review of the final decision of the district council. That's extract 515. Second, with respect to Judge Houghton's question about the planning board's decision as to whether it was a recommendation or a decision, I responded by saying it was a decision, and I would
within the context of an SDP.
Yes,
correct?
It's a resolution, extract 358-371.
Thank you.
My adversaries argued that my reference to the merchandise logistics center definition and the related testimony was not in the administrative record. It's not in the administrative record. We cited it as legislative history in accordance with this court's jurisprudence, where we can look at the legislative history to help us understand the meaning of a ordinance. So that's why we cited it. My adversaries were critical that I spent a lot of my time responding to the court's questions and not going through the minutiae of our argument about why this is not a warehouse. I'd like to take just a few minutes and do that. We lay out this argument at pages 18 through 20 or 21 of our opening brief. I agree with counsel for the district council. The question is, what is the use? Not the name, what is the use? And the reason I opened my remarks at extract 008 is that's a good description of the use as described by, provided by Amazon. So the question is whether this is a warehouse. We have a definition of a warehouse unit. We assert, I think everyone agrees, a warehouse unit is a synonym for a warehouse. A warehouse unit is defined on the zoning ordinance as a building used for the storage of goods and materials in connection with the day-to-day operation of a wholesale or distribution business. All right, so what are the elements? Needs storage. We have a debate as to whether there's storage or not. Your Honor asked whether there's any time limit. I said no, that's one piece of the puzzle. So we have that legal question. Is there storage? We assert no. It's only there for a matter of hours. We assert that's not storage within the context of the zoning ordinance. But storage in connection with the day-to-day operation of a wholesale or distribution business. No one has asserted that this is a wholesale business. People are pointing to, my adversaries are pointing to distribution business. Well, we have a definition for a distribution facility in the ordinance. And the district council's lawyer argues this is a distribution facility. We have a definition, which is cited in our papers and attached to the brief. Distribution facility is defined as follows. A facility to or from which a wholesaler or retailer ships merchandise, materials, or supplies for storage and distribution by that wholesaler or retailer to the sales outlet or service operation it supports. That's subparagraph A. Paragraph B. A business whose functions are similar to those of the United States Postal Service that is exclusively devoted to the receiving, sorting, sending, and delivery of letters, parcels, and other postal express matter. Now, in our opening paper, we went through these words, word by word. We laid out the argument as to why we read this definition to say that the Amazon last mile hub, as defined by Amazon at extract 008, is not a distribution facility, even if this court finds that there's storage.
I have a question.
Yes, sir.
You mentioned that it's limited to wholesale or distribution business. But isn't there a third category of business that is not located on the same?
I didn't mention that because no one's argued that, but let me pull that out for the court. Except,
it's a business that is not located in the same building or on the same property as the warehouse. Isn't Amazon located in a different building than this particular unit?
No one's argued that before. The reason I didn't include that in my, we're on a time crunch here, but I believe that's where they're shipping the material from the last mile to that other business. I don't think that's applicable here. And the focus of this case has been, do they fall within the category of a distribution facility? And we argued at pages 19 and 20 of our brief, if it please the court, that they don't satisfy part A of the definition because they're shipping products to an end user, we all know that, to a customer, not a sales outlet or service operation it supports. Then we say it doesn't satisfy part B of the definition because their functions are not similar to the U.S. Postal Service. The Postal Service sorts letters and parcels for anyone in the public and delivers them to other members of the public. In contrast, Amazon ships its own products from a fulfillment center to the last mile facilities, which sorts and delivers the products to the customer.
So is this really sort of an amalgamation of the two? Sort of has elements of A and B?
No, I don't think it does. I think it's closer to, if I were assigned the task of writing a definition of this use, I would look at the definition of merchandise logistics center. I would look at the from 2019, I would look at the definition of the ordinance for warehouse distribution and try to merge those two in a way that was easy to read and easy to understand.
I understand, but we're interpreting what's there, and you have A and B, and you say, it seems like what is described has elements of sort of the incoming part of A and the outgoing part of B.
It's going to be one or the other. It says A or B. I understand Your Honor's point. I don't agree with the point, but I'm saying even if Your Honor's right, you can't have part of A and part of B. You got to be either A or B as per the ordinance.
So if we're looking at it for what it does, and it says you can do either of these two things, you think it has to be to meet all the particulars of one, rather than saying, well, clearly they were saying that this kind of operation, doing these kinds of things, is okay, and we can't pick the elements of it, is what you're saying.
That's what I'm saying. I'm saying it doesn't meet either definition, but if you thought it met part of A and part of B, it doesn't get you there.
Why isn't it similar to the U.S. Postal Service?
I beg your pardon?
Why isn't the use here similar to that of the USPS? I mean, it doesn't say identical, but it is similar in that the product goes to the consumer, just like the mail goes to the consumers, to the people.
Well,
isn't that similar?
You know, I'm an advocate, of course, you know, but I say it's not similar. Why is it not similar? This is what we wrote in our brief at pages 19 and 20. Anybody in the world can drop an envelope in a mailbox and have it sent, if the system works, to anybody in the world.
Right, but you're focusing on how it gets to the building, as opposed to what is happening at the building. If you focus exclusively on what is happening at the building, isn't this similar to the U.S. Postal Service in terms of its delivery to the
Right. I think what the court is saying, because they're sorting envelopes and boxes at the post office, isn't that similar to what's happening?
And they're loading it onto trucks to deliver to the recipients.
I mean, this may go to Judge Feder. You know, maybe part of it might be applicable, but
Well, the word is similar. It doesn't say identical.
right. But what's the core element? If you and I are running a post office, what's the core element? Anybody in the world can send us something. If you and I are running an Amazon last mile facility, what's the core element? Our stuff only comes from Amazon.
But the purpose for which we're looking at these questions is zoning, right? It's for looking at the facility. So in line with what Judge Gould's saying, if we're looking at whether it was intended to fall within the definitions that we have here, shouldn't we be looking at what's going on in the facility rather than looking at the definition saying for some other purpose it's not relevant to the use of this property, is it the same or similar or identical?
It's all murky, isn't it? And
It's all what?
all murky, isn't it? So,
Well, doesn't that get then to deference?
no, because that's why we have to look at the legislative history. And we know that before this event, they defined emergency logistics center, define a way that describes our use. And after this event, they come up with a warehouse distribution definition. And when you look at all this material together, we assert the only reasonable conclusion is that this facility is not a warehouse, and they're not out of luck. They can petition to amend the list pursuant to the comprehensive design document. Thank you all for your time. We appreciate it.
Thank you all for your arguments. The court will take a brief recess before the second case of the morning.